Yay, we're live.
I don't see you on Instagram yet.
Mr. Shaver Esquire.
Well, hello.
Hello,
I'm
hello.
trying to fix this here. Why is this not?
So what's on the menu today?
What is an attorney?
I'd like to
You're-
know.
It's kind of like a public adjuster.
Yeah.
It's like public adjusting light, you know?
Guessing light. That's all we have to talk about. A couple things I'll talk through shortly. I put out the new edition of our newsletter today. I'm going to talk through a little bit about that and ask some of Cody's thoughts on what I wrote about in there.
My thoughts.
Yeah, your thoughts.
Mm.
Let me see. I think my dog's wanting to come in here for office hours. Just a second. I'm gonna let her in.
So, Cody, that latest one, we set it up pretty good.
Which one?
Well, I'm not sure I can see.
We're live. We're live right now. So
Yeah. But I
you
think
don't
they
get
have
into too many
everything they need.
details.
Right. I'm not going to say the
Right.
name.
There we go. All right, and YouTube comments, they come to here directly, right? Yes.
Yep.
So I have the other one.
YouTube comments come here. Facebook comments come here. Instagram is the one that does not oftentimes.
All right, cool. I'll watch Instagram then.
All right. I think Stosh is watching on Instagram right now, which is important. He actually is a Tugboat user. He has had the benefits of Tugboat for his hail claim. The funny thing was, if Stosh is watching right now, is that he is a friend of mine and one of my closest friends. And so I talk with him about Tugboat all the time and our ideas for it and just the business and how we're trying to grow it. Super smart. Always has good feedback. And so I was asking him when we thought of the membership version of it, like, hey, we want to start a membership that people would pay for when they don't have a claim. We'll help them be prepared for one. And then if they ever do have damage, they can come to us first before filing to know, whether or not they should file a claim and what they should do. And Stosh, let me know if you're watching this on Instagram. And so he's like, I don't think it's something I would pay for. I'm like, really? $5 a month? Like $60 a year? I'm not good enough for you? Like all that help I can do? And he's like, I just don't know. I don't think I'd be the type of person to pay for it. And I kid you not, it was like a week later, a hailstorm goes through his neighborhood and hits his house pretty good, knocks over a tree that falls over onto his roof. His house is like brand new. And he calls me and he's like, Cameron, I don't know if I should file a claim. I'm like, Stosh, this is what Tugboat's for. This exactly. And the funniest thing about his was, this is actually a fun story. He calls me and he's like, hey, I don't know if I should file a claim. And this is what happened. And then he tells me what steps he's taken. He had called his insurance company already. Chris, are there a lot of roosters there?
There's an abnormal amount of roosters near me. I'm trying to figure out what to do about it. I'll mute myself.
That's Chris. Chris has a rooster. It's not bad. It's
loud.
But anyway, so I'm talking with him about it. I'm like, well, Stosh, like one, you should have said yes to my Tugboat membership, even though it didn't exist yet at the time. And two, you already filed a claim. He's like, no, I didn't. Like, I didn't file a claim. I'm like, you did. And he's like, no, I didn't call and report a claim. I just called and talked with him about whether or not I should file a claim. And he told me like what was happening. I think they were going to send someone to inspect. And I was like, I bet if you go online right now and log into your insurance profile with your carrier, you're going to have a claim open. And he's like, no. They assured me, like they told me I didn't have a claim open. And he logs in right then And sure enough, he's got a claim number, an adjuster assigned. And I'm like, so the question of whether or not you should file a claim is out the window. You have officially filed one. Anyway, so it was really funny. Then they told him like, well, we could just delete it essentially. I'm like, I don't think they can. Like most carriers won't do it, even if they could do it. And I'm not sure if they can do it. And then you come to find out they had told them that they could, and then they couldn't. I'm like, okay, so you have a claim now. Let's make sure that they address everything that they're supposed to. And it ended up being, a serious, it was like $15,000 claim. Had to get his roof repaired, had to get his fence repaired.
Gutters, fence, and stucco.
Yeah. Nothing like crazy major.
No.
But anyways, yeah, we recorded a video with him in which he talks about this story. So we got to post that eventually. But he now believes in Tugboat. I don't know if he'll pay $5 a month for it yet. He knows how important it is. He knows how important it is. We've had it happen to a couple of Tugboat users where people don't know this. But don't call to talk to your insurance company about damage to your house unless you're prepared to have a claim open. Because we had someone who has a claim open, just ask the person on the phone with State Farm. They called the general number like, hey, I just want to know like if something like this would be covered. I don't know if I want to file a claim. And suddenly she had a claim filed and immediately denied because it was not a covered issue. And it's like, okay, here's another claim on your record.
Yeah.
And then she probably got dropped because it was 2 claims in 3 years.
Yeah.
Cody, what do you know about the kind of underwriting and policy side? People ask us really often, like, oh, how many claims until they'll drop me? Does the size of my claim matter at all when it comes to how they set my premiums or whether or not they decide to drop me? Because when we were on the carrier side, they essentially told us that the size of the claim didn't matter. It only mattered whether or not they had a claim and how many they had. Didn't matter if it was denied or anything.
You're absolutely right. That's the rule is that my understanding of underwriting is they're not supposed to inquire on the amount of each loss to judge it based upon the size. It's, it's a cost benefit, cost savings, are they going to make money off of it? So it's the number, are you pro to have additional claims? Usually people who file claims tend to have more claims than people who never file claims, right? Yeah. So it's really based upon the number of claims that you filed, not the amount.
Yep.
That's what they say. That's what they say.
That's what they say, but I've also had like a client of mine that had an $80,000 loss, but when I got involved, it turned into $1 million loss, and they dropped him after that point.
So Chris just ruined the whole theory that we just talked about.
Because the claim had been going on for nearly a year before I got there, and then they got said because of the amount.
Well, they didn't cancel. Yeah, they didn't cancel. You're cutting out a little bit. They didn't cancel, I'm sure. They just non-renewed, right? So that might have been in the process already for non-renewal, regardless.
That's what they'll say, at least, right? That they, we have Tugboat users where because you're not allowed to drop someone for the wildfires, right? But they came up with another reason that sounded really suspicious as to why they would get non-renewed that wasn't wildfire related.
Yeah, we were reviewing your claim, and before the wildfire, you had a tree too close to your home. So
yeah,
yeah. We've got a Tugboat user right now, not with a wildfire loss, but he has a water loss, and he got a notice of non-renewal, and it listed one claim as the reason for the non-renewal. One. Yeah. We just talked to him yesterday, or Monday. You and I did.
Wow.
Yep. I have one that is in the carrier that you're in good hands, and they, after the fire, total loss fire, non-renewed the insured, and then they canceled their policy and then made them buy another policy that was 3 times as much without the house there. So I don't know what, and then eventually after I got involved and a whole bunch of arguing back and forth, eventually an agent found them, got them on a course of construction policy, but it took months. It's 4 months now to do that.
Yeah.
But those aren't cheap either.
No, it only saved him off of the increased rate. It only saved him a few $1,000 a year off of 15.
That's actually something that should be discussed, is about a course. A lot of people don't know about a course of construction policy.
Yeah.
Yep. Tell us about it, Cody. Tell us about a course of construction policy.
Always put me on the spot. Course of construction is just an insurance policy that protects you as you're building the home, right? So you don't have a structure. So a lot of people, seminars that I went to were telling people, hey, go ahead and cancel your insurance. You don't have a home anymore, but you need something, right, during the course of construction.
Especially for liability.
Correct. Liability, everything. What if the house burns down again? We just had, it was about a year ago, had a house that had burnt down, and as they were rebuilding it, burnt down again. Right, plumber did some soldering, and it caught some insulation, and it smoldered for like 2 days. It smoldered. No one even knew it was happening. People were working there during those 2 days, and then house burnt down. So they luckily still had their insurance, but a lot of people are canceling their insurance because they don't have a home anymore. So you can get a course of construction, but they're cheap. Did they tell you how much that course of construction insurance was?
Chris.
He's frozen. The roosters got him. Roosters got him.
Are you saying that they're generally more expensive, Cody, the course of construction one?
I don't know what the price they are. I've only had one client that I've actually got into it. It was a fourplex, a big one, and it was $6,000. They went from $6,000 a year to almost $6,000 a month for that course of construction insurance.
Wow.
Yeah.
That's crazy.
Yeah, I know the one that I just had too was pretty expensive. It was less than their increase.
Mm.
I'm not going to feel bad for him because he's freezing out because he's in Hawaii.
Yeah, I know. It's just no sympathy whatsoever.
Yeah.
Not even a little bit.
And got a trip there for weeks on an ice island.
Yeah. Joe Carl, I was wondering about the chicken.
Yeah.
He's in Kauai, Joe. Thanks for joining us, Joe, as always.
He's house sitting in beautiful Hawaii, and they have roosters apparently.
Yeah. So I shared the link to this actually. Oh yeah, in the chat here, and then people on Facebook can probably see it as well. To the article that we wrote in our newsletter. So our newsletter is called Dawn Patrol. Sometimes we write just about starting a InsurTech startup, and sometimes we write specifically about insurance and policy and things that we deal with here. That's what this one is. So we called it the Great Rewrite. Aaron actually helped me a good amount with it and got it off to a good start, and then I finished it up. But Cody, the topic of it is how coverage has changed without policy language changing over the last 10 years, right? And this is, I say at the top, or like when I posted it in LinkedIn, I'm like, everyone in the industry knows this because we all talk about it, right? And the what's the phrase I put in the post? That used to be covered, right? Like, and that's like what the way that we would probably all talk about it. It's like, oh yeah, like that used to be covered. When I was an adjuster, we used to cover that. When I was an adjuster, we used to cover that. And it's not like the policy language has changed dramatically. I did a pretty decent deep dive on, because we talk about the State Farm period of time language that they have in their policies pretty often. And I wanted to know, like, when did it look like that was adopted? And does it, because the way that we've talked about it before is essentially when a carrier, and again, Cody, you correct me if I'm wrong, you'll know more than me here. But when a carrier wants to update a policy, they have to submit those policy changes to, I can't remember what the organization is, but it's through the NAIC and then state specific. And they have to say whether or not it materially affects coverage, right? Or if it's just a clarification and it's not really changing anything there, right? It's just clarifying what it already says. And I'm fairly certain, I couldn't find specific details on when State Farm submitted that policy language, But it seems like that's exactly what happened there. It's not like they said, hey, when we change our language from weeks, months, and years, a leak that occurs over a period of weeks, months, or years isn't covered, to a leak that occurs over a period of time isn't covered. I'm fairly certain that they did not advise that was going to diminish coverage, but we all know that it did, right? Like, there's no doubt, I don't think in anyone's mind, that State Farm denies more water damage claims today than they did 8 years ago, before this language existed, right? So am I right in my assumptions of how that process is supposed to work, Cody, when it comes to policy?
Yeah, they have to get approval, and has to be approved, by the state as well, right? They have to approve it, but it makes you wonder how much research, is the state actually looking into these? There's a carrier who has a policy that they issued in the state of California that says they don't pay for overhead and profit until it's actually incurred, right? Until they actually hire a general contractor and incur the overhead and profit. But that violates the regulation for the state of California, right? They have to pay for what would be reasonably owed. So how did that language get approved? Like, are they even comparing it to the regulations? So we have one right now in litigation where we're arguing the same thing. And when I was dealing with it through the claims process, the adjuster just kept saying, well, I doubt that it violates any regulation because the state approved it. And now they're saying, now the counsel for that same carrier is saying, oh, it was just a mistake. It was blanket language. And in the guidelines, adjusting guidelines, they're supposed to ignore that section. Well, why did that section even get approved in the state of California? They know that violates the regulation. My thing is, well, how many people don't question it? Because they had denied the overhead and profit, and I started questioning it. So how well is that review process? That's, a concern. Why are they approving things? Who's I don't know who reviews it, right? It's not me. But yeah, I don't know specifically who, let's say it's the Department of Insurance for California. Who's reviewing it, right? Is it council? Who? Because a lot of things are getting passed through that I would say that, prove that they violate the regulations. The whole one that you just mentioned, I would have thought when that language first came out, I think I was the same as everybody else saying, oh, that's ambiguous. How could that get approved, right? There's case law that says that it's not. So, but getting back to what you talked about, the original discussion was coverage changing without modification of the language itself, right? So you're talking about one specific where the language was changed. How many policies have you seen over the last 10 years where the language didn't change at all, but how they apply it changed, right?
That's the main point of the article, right? And where I see that being most heavily abused is in the wear and tear exclusion, right? So I see wear and tear getting applied in areas where it was never applied before, and it's just much more liberally being thrown in as a cause of loss. And Cody, we've talked about this endlessly outside of office hours, but it seems to be the standard denial letter from several of these carriers. When they don't want to cover something, they say that it was caused by wear and tear, which is such an elementary mistake, and that you're like, it isn't even a mistake, right? Or is this just now your standard estimating guidelines or claim handling guidelines that says that you call damage like this wear and tear when it has?
Sorry, we've seen evidence that it's coming from the top down, so that would make it seem that it is intentional.
Well, I would agree with that. We just had a claim from the wildfires that they were saying that the certain carrier was saying, well, we have this particular client has an endorsement, and that endorsement means that we don't offer reasonable uniform appearance. And my first question is, well, this is a replacement cost policy, correct? And they said, yeah. The field adjuster, right? So I go back to the field adjuster and I asked them the same question. They stated mirrored the same position as the field adjuster, and declared that they were in the same onboarding class, that they were trained the same way. There's no coverage for a reasonable uniform appearance. They only owe for the specific, as if it were an ACV policy, right? Only for the direct physical damage. And I questioned it, and they came back and said, nope, you're right. You're right. We do owe for it. So that's telling me that that's not a misinterpretation by an adjuster. You have two separate adjusters interpreting it the same way. They were trained that way.
That's
So
what it seems.
jump
Yeah.
on what Chris is saying. It is coming from at least on some specifics, it's coming from the top down, because this is how they were trained, and it completely violated the regulations. And it had, reading the endorsement had nothing to do with reasonable uniformity. It just says how we settle a loss. We will replace, items that sustain direct physical damage. Didn't even mention anything about reasonable uniform appearance, which the policies don't. One of the things that I'm seeing with wear and tear a lot, maybe it's a little bit different, but some carriers say we don't cover for wear and tear, like roofs, right? A lot of carriers say we don't cover for the wear and tear to the roof, but we will cover the ensuing rainwater damage, right? As opposed like farmers requires a storm created opening, or a covered peril must create some kind of damage for the water to enter into. But other carriers, they say we don't cover for wear and tear. However, we will cover the ensuing damages unless the ensuing damages are otherwise excluded. And then they're going right back and saying, well, we don't cover for wear and tear. The rainwater is for wear and tear. They're ignoring the ensuing loss provision.
Yeah.
So you're seeing that kind of interpretation, which is odd.
That's the one I see the most, I think.
Yeah, and unless it specifically says that we don't cover rainwater unless there's a storm created opening, they can't deny the water intrusion. But one of the big ones that we've seen over the years is, I forget how long you guys were doing this, is backups, right? Some carriers aren't covering any type of toilet overflow, and they're calling it a backup. And it's funny because the language giving coverage says, overflow. We cover for an overflow of water from a plumbing system. Then it says, well, we don't. Then the exclusions, it says we don't cover a backup. Okay, well, is it an overflow or a backup? Back years ago, there was a distinction between the two. A backup was something from the city main off premises. The water's backing up, reverse flow coming up into the property, and an overflow was a blockage within your own plumbing system where the water was overflowing, right? There's a blockage, overflowing up, right?
They got rid of that language. I thought that was still in policy language, that it explains the difference between it, and they're still denying it.
Well, I don't see where they're explaining the difference, but now they're applying everything. There was a case that said where a judge says backup, overflow, it's all the same. Well, according to the policy, they're different, right? You're using two separate terms, overflow and backup, which means they should have different meaning. But the courts are saying, or insurance companies are saying, nope, it's a backup. And we'll say, well, it's on premises, right? The way that, people that I know that were trained as adjusters, they would always say, and I confirmed this with a manager for a pretty big carrier, and they always said, it's kind of funny, they said, well, if it's your poop, right, it's covered. If it's someone else's poop, it's not covered. Right? That's how we'd always ask, well, whose poop was it? Well, it was, someone else's. So, okay, that's a backup. That's not covered. But now they're just saying, oh, toilet overflow, not covered. Residents Mutual does that a lot. They don't cover toilet overflows, right? You're seeing that. And sometimes it's kind of adjuster specific. You'll get the same loss and they'll say it's a backup. And then another adjuster might say, oh, no, that's covered. It's an overflow. Well, what is it? There's no continuity in the training. So is it coming from management? I think it's a combination of lots of things.
I think that the thing that specifically we were talking about is this wear and tear, like the wear and tear situation is being held up by management and across multiple states and across multiple adjusters, especially on the big ones. And it does seem like they're being told to just deny wear and tear as if it's a cause of loss, regardless of the ensuing damages clause. And so that's the biggest one that I've seen.
There's one. Rachel and I were reviewing a tugboat user's denial letter yesterday, where it was so funny because the way it was denied, the adjuster almost named the ensuing loss language in denying it. It was weird. Like they said, we don't cover this wear and tear, and therefore we don't cover the ensuing damage that comes from it. I'm like, no. Like the language says that you do. Like that. Like that's specifically what you do cover.
That's the
And that was a manager. That was a manager.
But that's the entire premise of an ensuing loss. That's the purpose, right? We don't cover the peril is excluded, but we cover the damages. So we always say when you're dealing with an ensuing loss provision, you disregard the cause of loss. It doesn't matter. Yep. You're only looking at the damages, right? The damages are, let's say it's a wear and tear to a pipe, and then it floods out a house and water damages, the floors and the cabinets. That's all your focus is on ensuing loss. So they always want to bring back the cause of loss, and you try and reel them back in saying, we're dealing with an ensuing loss provision. It's irrelevant what the cause of loss is, right? So, but on the wear and tear, let's just focus on that. I've seen carriers where they don't offer a reasonable uniform appearance because the floor doesn't match because it's worn out and, wear and tear. So we don't owe for it because we don't cover for wear and tear. That's a stretch, right?
Yeah.
So,
Lots of things are a stretch. Rachel, can you find the denial letter we were talking about yesterday? So you can read it for us in a moment, because I think that would be a little entertaining.
My grammar is far too good.
Yeah, no, read it. You have to read it. You have to. We'll know it's not your fault that the words come out the way that they do. As you're reading it, I did a little bit of research just using Claude AI into the timeline, because again, this isn't an example of policies changing without the words changing. But if I read the timeline correct, with Fair Plans, when they submitted the change to their policy for smoke damage in 2017, I think it was, they submitted that policy language. They told the state, from what I can read, that it did not diminish coverage, that it clarified coverage for them, but then immediately told their agents that it meant that all these claims were going to get denied, that essentially it did deny coverage. So this is which is the whole stance for the class action that's going against them right now about the policy, is the fact that they essentially tried to say, oh, it doesn't diminish, it clarifies what direct physical loss is, but we still cover the same thing we always did. It's just direct physical loss. So even the ones where they are changing the language, they're not playing by the rules in saying, when they do change the language, when it does diminish coverage, right? And letting people know that it does. And what I hypothesize, and we hypothesize in that article, is that they don't want to have to deal with the fallout of that, right? The fact that you're going to have to admit that your policy just diminished publicly. And so what are the ways that you stay competitive when you can't admit that you have less of a policy? Well, don't change the policy, just have it restrict how it acts, or change it, but pretend that you didn't change it and then restrict it at that point, which is what Fair Plan is doing. And I'm curious, Cody, on the legal, because I assume maybe you've followed the legal case against Fair Plan a little bit better than I have. I know Dylan Schaefer's involved with that one, or at least one of the lawsuits against them around their policy. The Fair Plan was told by the state that their policy change was illegal, right? Once they started denying claims based off of this change that they did. And why doesn't that carry more weight for carriers, right? Does the Department of Insurance saying something is wrong, kind of what authority does that hold? Because even some of the bulletins that Laura and the Department of Insurance has put out since these fires, we've talked to adjusters that have made it really clear that they don't really have an intention, or their carrier doesn't have an intention of following it. They take it as like we appreciate you telling us what you want us to do. We don't have to, essentially. So what authority does the Department of Insurance have in that instance?
In my experience, the Department of Insurance has no authority to enforce their regulations, right? What's the Department of Insurance saying, right? Your policy language violates the regulations, correct?
Yeah.
And they don't have the authority to enforce their regulations. So what authority do they hold? That would be a great question for anyone to answer, right? What authority do they have? They have the authority to audit, right? They can audit and for, I guess pattern and practice and stuff like that. But, they don't have the authority to enforce any of their regulations on a specific claim. So what's stopping an insurance? And I'm not saying that they're acting maliciously, but what's stopping an insurance company from violating the regulations on a policy language if there's nobody that's going to actually have the authority to enforce it? What repercussions are they getting? None that I am aware of. Yeah. You spoke with some counsel that was doing those cases. obviously people are complaining to the Department of Insurance about it. Can't just be, a lawsuit being filed by, you said Dylan's filing it, right?
Mm-hmm.
Some of those people, what happened with the people that filed complaints? Nothing, right?
Mm-mm.
So there's no authority. So where do you go to get some kind of remedy for those? Well, apparently you go to Dylan, right? Or you go to attorney and
Yeah.
enforce it. They're the ones that can, act and kind of determine if there is a violation, right? Based on public policy, I guess.
While we're on this topic, Rachel, we'll come back and have you read that denial language in a moment. But let's talk about for a second the role of a Department of Insurance complaint. I'm most familiar with these in California, but in most states, they seem to function fairly similarly. So for those that are watching that may not understand, if you have an issue, it'll say on almost every letter that you get from your insurance company that if you have some issue with what we're doing, go ahead and reach out to the Department of Insurance and let them know and file a complaint, right? And it'll even say, and if you go on the Department of Insurance website in most states, because we've researched this, and you look at what their charter is and what they're supposed to do, you'll be encouraged for a moment. You'll be like, oh my gosh, they're here to help me solve this problem when an insurance company isn't treating me fairly. Because you look at California's charter, North Dakota's charter, several other states. And in North Dakota right now, Aaron, our co-founder, he's the public adjuster on a claim out there. And he is literally like in the process of begging the Department of Insurance out there to step up to the plate and get more involved in a dispute that's happening. Because essentially, if the Department of Insurance isn't willing to uphold the regulations in any way, then the only option is a lawsuit. And so he's trying to say like, hey, you got to give people another chance, another option. You have to step in and do something. And it was actually interesting there. They're trying to figure out what they can do, essentially, is what it seems like is happening with North Dakota. But so if you get a letter from your insurance company, you get a denial letter, it'll say at the bottom, you can reach out to the Department of Insurance. You go there, they have a consumer affairs portion of their website. You can file a complaint. It's pretty easy, right? You tell them what was wrong, upload some documents if you want to. And in California, at least, you're going to get a rep assigned that's supposed to review that and decide what to do about that information. So in my experience, one thing that the Department of Insurance complaint is good for, or the main thing at least, is if you're not getting any answer from the insurance company, you will get an answer. Right. So in that way, it's not useless, right? That does have some use, because there are times where we'll go a month and nobody responds to an email or a phone call. And then the Department of Insurance gets involved and finally we get a phone call back, right? Or they have to respond to the letter that was sent to them. So, but beyond that, Cody, does the Department of Insurance complaint serve another purpose for the average homeowner that's being mistreated in the claims process?
Not in my experience, no.
No.
All they can usually, they're overworked, right? I mean, we know that they're overworked, and I think they want to do a good job. These investigators. I think I told you a couple of years ago, 32 investigators, 500 complaints a day. Right, that's it. So that's 11,000 complaints a month is what they're fielding, and there's only 32 investigators. That might
California?
In California. That's about 4 years ago, maybe 3.5 years ago, 4 years ago, in a conference call with them. That's what they were saying, that they do their best they can. That's why they really just take your letter, whatever letter you write, they'll send it to the insurance company. And you're right. When we're not getting a response, I always tell people, hey, just file a complaint. It'll go to a manager and the manager will respond. Now, if that's containing truthful information, right, or if it's a jaded version of the facts,
always.
But at least someone's looking at it and you can show. As far as, if you're looking at filing litigation afterwards, it does help, right? Because what you want to do, and I suggest to everybody, is exhaust every avenue. And even if we know, and not bagging on the Department of Insurance, I would never, but even if we know it's not going to be beneficial, I always tell people, file a complaint, to show on paper you've tried everything that you can, and this is your last thing that, you didn't even want to do it, to show that they compelled. I had no other alternative, right? Especially in these state of emergency wildfires, you can't go to appraisal, right? It's not mandatory, it's voluntary. Department of Insurance. The Department of Insurance has a mediation program, right? But it's voluntary as well, I believe.
Yeah.
If you looked into it, they have to agree to it and exhaust all of them, right? Especially if you're going to hire an attorney, because attorneys are expensive. So it would be beneficial. It would be beneficial to exhaust all those avenues first. So again, even if we know it's not going to work, it does show on paper that you've exhausted every effort.
Yeah.
So anyways,
Yeah,
it's funny, real quick, you brought up this state of North Dakota. I worked as a public adjuster there years ago, and this was probably 10, 15 years ago. I was there, and I had one claim, and my experience, and I'm sure it's changed, is the insurance company, even if you're licensed, they don't have to talk to you. They don't have to.
So out there, they didn't license PAs out there back then. That's probably why they didn't have their licensure until about 3-4 years ago.
No, well, you try and help people out there, and I was talking to some other Department of Insurance and said, well, what does an insured do if they have a problem with an insurance company? And the person on the phone, very sweet, said, well, what kind of problems would someone experience? And I said, well, let's say that somebody has a loss, a tree falls on their house, and the insurance company, their estimate, the insurance estimate is $50,000 to fix it, and the insurance company's estimate was $5,000, and the insurance company's saying that's all we're paying. And she actually said, oh, that's never happened in this state. If you have this carrier, and I won't name names, if you have this carrier, I guarantee you it's happened a lot. But I said, I can't help these people there, so I never went back. But it was, so maybe things have changed, right? So now you can get
they licensed PAs a few years ago, and it's actually really interesting because it's a smaller state. We have a good working relationship with the Department of Insurance there. Our company was founded out of North Dakota. My co-founder is from there. And so we've gotten to talk to their commissioner out there. He's a big fan of Tugboat. There are agents in North Dakota that have sent people through to Tugboat. And yeah, it being a small state with a smaller Department of Insurance has its own problems. But when you call, someone answers the phone, right? And it's the same insurance companies generally out there that we're dealing with here. So it really is the same issues. But people are less likely to dispute probably there, even if they are being wronged. And what's crazy, because we were talking with the Department of Insurance out there about legislation that was upcoming. They were asking our thoughts on different things, and really, really nice people. And what was I going to say about it? That oh shoot, I lost my train of thought. Regulations that were coming up through there. One of the legislators there encouraged us. He's like, hey, you should go, and I know you can do this for any state, go on the legislative website and see who all of the who are the people, what are they called when they're paid to go? Lobbyists. You can go see who every registered lobbyist is for the state of North Dakota and which company they lobby for. And so when we were talking with some legislators out there about some legislation that we thought might be beneficial, they're like, okay, well, just so you know, you should look up and see which lobbyists you might assume, which companies you might assume might be opposed to this, and how active they are here in lobbying. And North Dakota being one of the smaller states population-wise, we're like, oh, who's lobbying there? It's not that much. But the large carriers each had several lobbyists. And they just said, like, when legislation comes up, they are informed really quickly as to whether or not a carrier would be happy with it. They'll fly their lobbyists in who will go and meet with legislators and tell them very quickly whether or not they should approve this legislation. And if you watch the arguments that happen on the floor of the legislature there, nobody is, I don't know, intelligently talking through like the what is actually happening with the policy. It's a lot of anger about what a public adjuster might do. Yeah. So, anyways, it's kind of a crazy process. All underscoring, we're still on the point of like, what's the role of the Department of Insurance complaint? And there, we're trying to. So, Aaron, my co-founder, is the only resident public adjuster in North Dakota. Every other one is licensed there from out of state. He's the only resident one. So yeah, we've gotten a decent little bulk of claims that have come through there that are using Tugboat, and some that needed a PA. And then one other misunderstanding people will often have when it comes to the Department of Insurance, David Princeton, an attorney friend of mine, he wrote the bad faith guide state by state for United policyholders. And I remember he had sent it to me to read because he outlines in there in which states you are that, what is it called? That when someone acts outside of fair claims handling guidelines, that it is bad faith or that it's enforceable. What's the phrase I'm thinking of, Cody? Like where bad faith is. Oh, you said it the other day too, and I can't remember. I'm too dumb to remember.
You're gonna remember, and I'm gonna get a text later on. And we're gonna go, oh yeah.
Yes, I know. Bad faith conduct is unreasonable conduct when you suffer a loss. Let me see. I'll find the phrase for it in a moment. But Cody, does the Department of Insurance have any involvement in someone's argument as to whether or not a carrier has acted in bad faith? This is what a lot of people believe, is that if a carrier acts in bad faith, the Department of Insurance can help me with that, essentially.
Yeah, what the Department of Insurance can do is listen, and maybe an investigator may state that it sounds like it, bad faith, it sounds like it, but they can't do anything about it. The Department of Insurance has no authority to enforce anything on a single claim, right? All they can do is audit and fine for patterns in practice, right? That's all they can do. They can't force an insurance company to do anything, even if they do determine that there's bad faith or a breach of contract or anything. They don't have the authority. So like you said, it's on the big picture items. It used to be they would do a lot more audits, and when they would audit insurance companies, they would actually fine. They would go through the files, and any violation they would actually fine them, and they would get big fines. And I was talking to a manager of a big, multi-firm, right, and insurance company, and I asked her, I said, when's the last time that you sent a status letter out? And she says, oh, geez, it must have been 5 years. I haven't sent a status letter out in 5 years. And I go, that was the point of my question, going, why? Which I knew why, right? And I said, why don't you send them? She goes, because we don't get audited anymore, and I don't have time for those. And it used to be like a $5,000 fine if they'd go through it, and they on an audit, and they would find that you were failing to send out status letters, but not anymore. So, that's why I'm sure you guys see a lot. You don't see status letters or anything. You see denial letters that don't conform, don't provide any facts. They just say you had a loss, pipe broke, flooded your kitchen. That's excluded, right? What do you mean it's excluded, right? Then they'll send 9 pages of policy language, and it's basically like, the denial somewhere in here. You send that to the Department of Insurance. What are they going to do? They ain't going to do anything about it. They can audit, but I haven't heard of anyone being audited in years.
Yeah.
I was just looking at a case that's actually in litigation, and got a motion for summary judgment, and looking, they never paid the undisputed amount, right? 14 months and went to appraisal. At 12 months, they still held on to the award after the 12 months, and then issued the final payment, and not one status letter ever went out, no undisputed. And there was a complaint that was filed with the Department of Insurance. There's no, you get a copy of the insured's complaint and a response that says that they're working on it, they're investigating, they've hired experts, and case was closed.
Really?
Case was closed. This is the response. We're closing our case. They've actually made it a little bit more difficult to file. We used to file them on behalf of our clients all the time.
Yeah.
And, we would file and just say that we have authorization. Now you have to get something signed. I don't know if you guys seen that. You have to have actually something signed by your client that says you can file it on their behalf.
Yeah, it's newer, right? And I don't feel like it's been consistent. I feel like sometimes we've been asked for it and sometimes not. Cody, the language I was trying to remember was the private right of action.
Oh, yeah.
What does that mean?
Well, it means that there's no private right of action for an insurance company to violate the. If you want to file like a lawsuit for the insurance company violating your rights on, not adhering to a regulation, say 2695.5, they don't send you any status letters, or 0.7, they don't send you a proper denial. You have no private right of action for violation of the insurance regulations. It means you can't sue them for that, right?
Yeah, so it's not. It's. I'll try and say it as a layperson here, and you tell me if I'm correct, because this is how I have explained it to people this way, and you tell me if I need to go tell them, oh, I was wrong. Essentially, an insurance company can violate claims handling guidelines by the state, right? You have to respond to communications within 14 days. You have to send status letters every 30, whatever it is. You have to have denial letters that explain X, Y, Z. So they can violate those, and it's a violation, and it may be evidence of a pattern of mishandling of your claim, but those things in and of themselves aren't acts of bad faith. So it's like they can help build the case that bad faith may have been committed, but no one of them can you say, oh, now that they didn't respond for 14 days, we can sue them because it's bad faith now because they violated these things.
Yeah, you can't allege bad faith on the violation of insurance regulation. Exactly what you said. You can use it to support it, but it can't be the main cause, right? We're looking for unreasonable conduct. And a lot of the case law kind of, mirrors those anyways, so unreasonable delays, right? There's case law on unreasonable delays and unreasonable conduct. And then to get more specific. So you always look at the regulations as a kind of a generic issue, right? Like the term unreasonable, right? That's kind of a generic term, right? What is unreasonable? So it's the case law that kind of, so let's say that they violate the regulation and you're alleging that it's unreasonable conduct because of violation of a regulation. And then it's for the courts kind of, I think, in my experience, to kind of drill down, what does that mean? What's unreasonable? Based on those regulations, what is unreasonable? So you do have case law that supports it, but it gets into terms like, unreasonable delay, not responding, a certain time, taking a year to, investigate a claim, not promptly investigating it. Those are issues in the regulations, right? Or unfair claim settlement practice, right? Fair reg. So insurance code, what is it, 790.3, I think, that lists a bunch of stuff that are insurance companies can't do. But you can't just allege that in your complaint. You'd have to get other conduct of what they've done, and you can do that by citing other case law. That's getting kind of into the practice of law. PAs can't do it. You hear a lot about, especially on LinkedIn, contractors acting as PAs, and then I think the next thing is PAs acting as attorneys, right?
Yeah.
Which is really odd to me because I get denial like letters all the time that cite case law and everything else, and I can go back and say, are you an attorney? Like, what is this? But, it doesn't do anything.
I do have a question around that, but I want to let Rachel read this now letter first.
I'm really excited to hear this. So we talk about it free time. I want to hear it. So she's laughing. So we're all gonna laugh at this, I'm sure. Right?
All right, Rachel, you read that.
All right. So it first started out, there was a proper denial letter, right? And then there were questions sent in. And so these supporting narratives that were prepared were, basically in response, just a conversational response. So again, questions asked, and the adjuster, this is actually the adjuster manager. The manager says this. I don't recall what the question was exactly, but it is going to page 6. Essentially, I do remember now, we had asked about this particular claim was denied with no inspection. And it wasn't just a mean, there was no inspection. So that was one of the questions. So it says essentially an inspection was not needed because based on the facts of the loss, the occurrence that occurred at your property was a continuous and repeated seepage and leakage, unfortunately. Condensation lines are not a line under pressure and only have water flow intermittently. With there being a leak in it, water will escape intermittently or repeatedly, causing damage to your property, which would not be covered under your policy.
I would really
You read that verbatim.
approve of the use of ChatGPT for these situations for those
It
people.
hurts my head to say it, to read that. Like that hurts
An
it.
occurrence that occurred.
Yeah. And there was no greeting, but literally that was, and then of course they ended with thank you. Not if we can provide further assistance or clarify again, just two very long run-on sentences and thank you.
Wow.
Ugh.
You know, I think everybody here was an adjuster at one time or for the carrier, right? And everybody here,
Yeah.
you know, you want to do a good job. You wanted to do what you thought was right. And I think that the adjuster that wrote that probably wants to do the same thing, but it's an injustice to that adjuster, not only to the insured, right? We can agree on that. It's an injustice to that insured, to that adjuster, right? It's an injustice. Lack of training, and that's the kind of stuff that they're being forced to put out because they don't understand. They don't
Yeah.
That's a
understand what they're
manager
doing.
though, Cody.
What?
That's a manager. That's the one training adjusters.
Oh my gosh, that was a manager that wrote that letter?
But here,
Sound like a
I'm going to
door-to-door
argue this
candy
for a
bar
second.
salesman.
This is my biggest. This is my biggest argument. So I've been an adjuster for this particular carrier, even, but I was an independent. My training, there was no real training, right? There is professional integrity you have to bring to train yourself. Some of this training that happens, you have to do. You have to. Part of that is speaking better English and understanding the policy. First off, like that,
Well, understanding the
that's a good
policy
start,
ought to
you know, but
be the responsibility, the onus of teaching that is on the carrier. So, I mean, yeah, that's.
I mean,
But here's where I argue with that. So it's words. It's words. We can all understand words. And if they're going to try to minimize from behind the scenes with their estimating guidelines, if me as a human person who can read, I can go, no, that doesn't apply. Like, because I'm going to try to, we're all supposed to find a reason to pay, right? So if we look in the policy for language that doesn't deny it, then you pay it. So I can speak English. I can read the policy. That means I don't need your estimating guidelines. However, this change in the policy that we were talking about earlier, that's not going to matter because I understand English. They just have to let people read it and have an understanding of like, let them understand it for themselves. It's English. Let me adjust, right?
Well, let me ask you this: what was the condensation line? Was it clogged or did it break? How'd it break?
It broke.
This is my favorite part.
Well,
This is my
actually, we
favorite
don't know.
part.
What's that? Chris?
Yeah.
Or Cameron?
Cameron said it's his favorite part. Why is it your favorite part?
Of this claim. Why did it break? Why did it break, Rachel?
Yeah, we don't know exactly.
Nobody knows.
We don't know.
What does that mean, Cody?
Well, if
It's obviously wear and tear then.
yeah, obviously.
Oh,
Well, because even if it was a
PVC.
condensation line and it's repeated and it happened every 5 minutes and a couple drips came out, if the peril that caused the line to break was covered, then everything ensuing from that's covered, regardless if it's excluded or not. So you have to keep going back. That goes back to the Howe case, right? That was the mudslide where they found that it was a fire. So
Yeah.
what broke that line? If they can't determine what broke that line, right? We don't know what broke the line. Maybe someone stepped on it. Maybe, maybe a raccoon fell on it, right? Whatever. We don't know. That's a covered claim. You know why?
It's an all risk policy. It's an all
What's
risk
that?
policy. If there's not something in the policy that they can find that excludes why that pipe broke, then it's covered.
That's my point. So there's no exclusion in the policy that says exclusion number 9, unknown causes are excluded, right?
Yeah.
they have the burden of proving that that pipe broke from wear and tear. And I'm sure they even put that in that letter, right? Or any letter?
And yes, the wear and tear was relied upon. And so I asked, I had the user ask, well, PVC being what it is and all, it's not really subject to the same type of wear and tear as like shingles or stuff. And they were like, yeah, but still, it's wear and tear. Like they thought actually, and then they actually pivoted and kept going back to the condensation.
Condensation itself is not covered. And therefore,
Yeah,
the
that's
condensation
exactly
that's
what he said.
inside the condensation line that exited the
Mhm.
condensation line is not covered.
Mm-hmm. Yep. And that was as craftily prepared letter as
Yeah.
the one I just read.
It might be important to let them know that
Yeah.
all water was condensation probably at one point.
Yeah.
Well,
Yeah.
I had
Well,
I had a denial for a
claim-
fire the other day, and I just got it. And they said, although the cause of the fire was undetermined, it more than likely was arson, which is excluded if the property's been vacant for over 30 days. And it's really funny because the property was vacant, right, for 30 days because they had a water loss with the same carrier that forced them to move out that they were delaying. So they'd been out for 6 weeks because of a water loss. They ended up denying both of them, but the denial letter that I got was more than likely it was vandalism and vandalism.
Oh my gosh.
Yeah, and
What a circus. What a circus we live.
but we're getting away from the burden. Who holds the burden of? And I think that's kind of the basis of insurance, right? To put the burden of proving the exclusion applies. I had one with a roof that says their own roofer came out. We had two roofers that said that the tree fell on the house and caused the opening, and that the water was coming in through the opening. Their roofer said it's likely, it's possible, but highly unlikely that that's where the water came in. And they said that's sufficient, denied.
Yeah.
And I go, well, what if it's, let's say there's a 99% chance that it didn't go through there, but there's that 1%, and this is the 1%. You're denying a covered loss. No, you have to prove that it came through that hole. How do I prove that?
Mhm.
How does an insured? Where does it say that in the policy? Right? It's an all risk. The burden's on them. So it's back to your PVC condensation line. How are they proving that it's wear and tear? Right.
So
They didn't even inspect it.
for us, Cody. So in that scenario, you just highlight that one more time because I want to make it clear. We'll make a little video maybe on this section. So if in your scenario, a tree falls on a roof, makes a hole in it, there's water damage inside after it rains, and based on where that water damage is, some engineer that comes out says there's only a 1% chance that the water actually came through this hole that it would have had to go through for it to be covered. There's only a 1% chance, but we can't know for sure where it did come from. Explain to me why that should still be covered legally as a claim.
Because the burden of proving, proof that the exclusion applies isn't satisfied by a 99% chance, right? You still have that 1% chance, so that would be covered. The question of coverage will always go to the insured. That's the way that the rules are. If you can't determine, or if there's any question, even if it's 50-50, 99-1, that gray area is always going to should always go in favor of the insured, right? Because of what's at risk.
Yeah, that makes sense. It gives a lot of clarity for that type of scenario. And usually it's not, there's so many different ways in which that argument seems to come up and get ignored by carriers. And even people that I'll see posting, people that know a lot more about claims than I do on LinkedIn, that seem to have a different perspective from the carrier side, that the onus of proof, the burden of proof falls on the insured. For some reason.
If it's a named peril, yeah.
Explain why. So if it's a named peril versus an open peril, explain that, and then we'll finish up.
Because a named peril, the courts, this is decided, it's law, right? That a named peril, the burden is on the insured to prove that their loss was caused by one of the enumerated named perils that are covered. On an all risk, that's reversed. So it's up to the insurance company to prove that one of the exclusions applies. So each one has enumerated items, right? A named peril has enumerated perils that are covered. An all risk has enumerated exclusions. And each one, if it's insured has to prove if it's enumerated covered peril, and the insurance company has to prove that it's one of the enumerated exclusions.
That's interesting. I didn't know that there was that difference laid out between a named and an open peril.
That's why we have problems with the FAIR Plan sometimes. So it's not their problem. I mean, a lot of those policies are named peril, and the burden is on the insurance company to prove that their loss was caused by one of the named perils. So people will call me a lot and say, hey, we got a named peril, and this is what happened. So I had one, right? And California FAIR Plan excluded it, and we got it covered because they never sent anyone to inspect, but the insured did, and saw that the contractor says that it looked to him like the line was cut. And, that was vandalism, which it was covered. That was the one where it was spray paint on the walls, and they told me it was a tenant improvement.
Yeah, I've had that one. I've had them call it spray paint on the walls tenant improvement.
Tenant improvement, yeah.
Public adjuster.
Yeah, and FAIR Plan people are great. I mean, the people I deal with are great, but yeah, that was a new one to me. But yeah, always that's why it's important. You don't see very many named peril policies. I'm sure you guys don't run into them that much.
Only on the content side. So like the contents will be named peril with many carriers, but in California, pretty much the structure is almost always an open peril policy. And now, or a modified open peril policy rather, right? Because they've modified it so much that much of it feels like a named peril.
Well, my ongoing joke is that it's no longer an all-risk policy; it's a no-risk policy, right? Because the way they interpret everything, which is kind of the subject of today, how they interpret everything, right? So it's a no risk. So we cover automobiles that hit your house only on Tuesdays and if it's a full moon. Right?
Yeah. Awesome. Well, Cody, we appreciate you. I'm going to end the live. If you can stay on for a sec, I have one thing I want to chat with you before we finish up. But everyone else, thanks for joining. Office hours are every Wednesday at 3 o'clock Pacific. Cody has been kind enough to join us most of the last handful that we've done, which is awesome. Tugboat.claims is our website. It's also our handle on Instagram and Facebook, and I think on TikTok. But reach out to us with any questions you want us to go over. I'm going to try to get better at posting throughout the week. Just, hey, if you have a question for this week's office hours, go ahead and throw it in. But I know that there are Tugboat users that log into this pretty regularly and learn from it, and are using the information and the things that we talk about in their own claim negotiations, which is what we want to see. So appreciate you.
Hey, Emily, by the way.
Always
Emily Bush.
saying hi to Emily. She's always here. All right.